Good morning, and welcome to today's episode of Legally Marette, Legally Raven Haired, and we're going to talk about transient presence jurisdiction, Burnham versus the Superior Court. Let's get started on our reading. We're going to do our reading earlier in the week this week so that we can be meditating and having it mulling around in our head for the entire period of our law office study. Imagine that Potter sues Dahlia, a Pennsylvania citizen in Hawaii, for a claim that arose out of an incident that occurred in Arkansas. Potter sues Dahlia, a Pennsylvania citizen in Hawaii, for a claim that arose out of an incident that occurred in Arkansas. Assume that Dahlia had never set foot in Hawaii and that the case has nothing to do with Hawaii. Shortly after the case is filed, Dahlia takes her first trip to Hawaii and is served with process, a copy of a complaint and a summons to appear in a case that Potter filed in Hawaii while there. Does the Hawaii court now have personal jurisdiction over Dahlia? During the Panoyer era, the answer was yes. Impersonal jurisdiction typically existed whenever a person was served with process while physically present in the foreign state. And that is precisely what happened when Dahlia visited Hawaii. International Shoe held that personal service of the defendant in the foreign state is no longer required. But even if personal service in the foreign state is no longer necessary to establish personal jurisdiction, International Shoe did not resolve whether personal service in the forum is still sufficient to confer personal jurisdiction. In other words, is a defendant like Dahlia still subject to personal jurisdiction in Hawaii because she was served with process while visiting the state on a temporary or transient basis? One might argue that if Dahlia's visit to Hawaii had nothing to do with the case, the answer would be no. The court said in Schaefer that all assertions of state court jurisdictions must be evaluated according to the standards set forth in International Shoe and its progeny. That is, all assertions of personal jurisdiction should be evaluated using the context framework, and in this case, the Hawaii court would have neither specific nor general jurisdiction over Dahlia. That seems straightforward enough. When the court said all, it must have meant all, right? Reading Burnham v. Superior Court, is the divorce action at issue in Burnham one spouse, Mrs. Burnham, sought custody of her children as well as financial support from her husband, Mr. Burnham, to grant these requests, which would affect Burnham's parental rights and his pocketbook. The court needed to have personal jurisdiction over Burnham. As you read the case, consider the following questions. Why did Burnham's temporary presence in California suffice for personal jurisdiction? How does the court distinguish his earlier decision in Schaefer? Will the defendant's temporary presence in a state always suffice to establish personal jurisdiction? If not, when does it suffice? Let's get started. Burnham v. Superior Court, 1990. Justice Scalia announced the judgment of the court and delivered an opinion in which the Chief Justice and Justice Kennedy join, and in which Justice White joins with respect to parts 1, 2A, 2B, and 2C. The question presented is whether the Due Process Clause of the 14th Amendment denies California court's jurisdiction over a non-resident who was personally served with process while temporarily in that state in a suit unrelated to his activities in the state. All right. Section 1. Petitioner Dennis Burnham married Francie Burnham in 1976 in West Virginia. In 1977, the couple moved to New Jersey, where their 2 children were born. In July 1987, the Burnhams decided to separate. They agreed that Mrs. Burnham, who intended to move to California, would take custody of the children. Shortly before Mrs. Burnham departed for California, that same month, the petitioner agreed she would file for divorce on grounds of irreconcilable differences. In October 1987, petitioner filed for divorce in New Jersey State Court on grounds of desertion. Petitioner did not, however, obtain an issuance of summons against his wife and did not attempt to serve her with process. Mrs. Burnham, after unsuccessfully demanding that petitioner adhere to their prior agreement to submit an irreconcilable differences divorce, brought suit for divorce in California State Court in January 1988. In late January, petitioner visited Southern California on business, after which he went north to visit his children in San Francisco Bay Area, where his wife resided. He took the older children to San Francisco for the weekend. Upon returning, the child no, he took the older child to San Francisco for the weekend. Upon returning the child to Mrs. Burnham's home on January 24th, 1988, petitioner was served with a California court summons and a copy of Mrs. Burnham's divorce petition. He then returned to New Jersey. Later that year, petitioner made a special appearance in California Superior Court, moving to quash the service of process on the ground that the court lacked personal jurisdiction over him because his only contacts with California were a few short visits to the state for the purposes of conducting business and visiting his children. The Superior Court denied the motion, and the California Court of Appeals denied mandamus relief, rejecting petitioner's contention that the due process clause prohibited California courts from asserting jurisdiction over him because he lacked minimum contacts in the state. The court held it to be a valid jurisdictional predicate for in-person jurisdiction that the defendant was present in the forum state and personally served with process. We granted certiorari. What does this mean? I looked it up before, I think. Mandamus relief. A type of relief sought where an individual or entity, most commonly one with governmental responsibilities, has a legal duty to perform a specific action but refused to. Mandamus, we command. A writ or order that is issued from a court of superior jurisdiction that commands an inferior tribunal, corporation, municipal court, or individual to perform or refrain from performing a particular act, the performance or omission of which is required by law as an obligation. A writ or order of mandamus relief is an extraordinary court order because it is made without the benefit of full judicial process or before a case has been concluded. It may be issued by a court at any time that is appropriate, but it is usually issued in a case that has already begun. Generally, the decisions of a lower court made in the course of a continuing case will not be reviewed by higher courts until there is a final judgment of the case. On a federal level, for example, 28 U.S.C. A Section 1291 provides that appellate review of lower court decisions should be postponed until after a final judgment has been made in the lower court. A writ of mandamus offers one exception to this rule. If a party to a case is dissatisfied with some decision of a trial court, the party may appeal the decision to a higher court with a petition for a writ of mandamus before the trial proceeds. The order will be issued only in exceptional circumstances. The writ of mandamus was first used by English courts in the early 17th century. It migrated to the courts in the American colonies, and the law on it has remained largely the same ever since. The remedy of mandamus is made available through court opinion statutes and court rules on both federal and state levels. On the federal level, for example, 28 U.S.C. A 1658A provides that courts may issue all writs necessary or appropriate to aid in their respective jurisdictions and agreeable to the usage and principles of law. Mandamus. I like this mandamus business. Mandamus. Okay, let's go back. The proposition that the judgment of a court lacking jurisdiction is void traces back to early English opinions. In Burnham v. Neff, we announced that the judgment of a court lacking personal jurisdiction violated the due process clause of the 14th Amendment as well. To determine whether the assertion of personal jurisdiction is consistent with due process, we have long relied on the principles traditionally followed by American courts by marking out the territorial limits of each state's authority. That criterion was first announced in Burnham v. Neff, in which we stated that due process means, oh no, sorry. That criterion was first announced in Penal Burnett, in which we stated that due process means a course of legal proceedings according to those rules and principles which have been established in our systems of jurisprudence for the protection and enforcement of private rights. 95 U.S. 714, 733, 1878, including the well-established principle of public law respecting the jurisdiction of an independent state over persons and property. ID at 722. It was in what was the classic expression of the criterion we said in International Shoe Company v. Washington that a state court's assertion of personal jurisdiction satisfies the due process clause if it does not violate traditional notions of fair play and substantial justice. Since International Shoe, we have been called upon to decide whether these traditional notions permit states to exercise jurisdiction over absent defendants in a manner that deviates from the rules of jurisdiction applied in the 19th century. We have held such deviations permissible, but only with respect to suits arising out of absent defendants' contacts with the state. Helicopterist Nationals de Colombia v. Hall 466 U.S. 408 for 1984. The question we must decide today is whether due process requires a similar connection between the litigation and the defendant's contacts with the state, where the defendant is physically present in the state at the time process is served upon him. Among the most firmly established principles of personal jurisdiction in American tradition is that the courts of a state have jurisdiction over non-residents who are physically present in the state. The view developed early that each state had the power to hail before its courts an individual who could be found within its borders, and that once having acquired jurisdiction over such a person by properly serving him with process, the state could retain jurisdiction to enter judgment against him, no matter how fleeting that visit. That view had antecedents in English common law practice, which sometimes allowed transitory actions arising out of events outside the country to be maintained against seemingly non-resident defendants who were present in England. Justice Story believed the principle which he traced to Roman origins to be firmly grounded in English tradition. By the common law, personal actions being transitory may be brought in any place where the party defendant may be found, for every nation may rightfully exercise personal jurisdiction over all persons within its domains. Recent scholarship has suggested that English tradition was not as clear as Story thought. Accurate or not, however, judging by the evidence of contemporaneous or near contemporaneous decision, one might conclude that Story's understanding was shared by American courts at the crucial time for present purposes. 1868, when the 14th Amendment was adopted, decisions in the court of many states in the 19th and 20th centuries held that personal service upon a physically present defendant sufficed to confer jurisdiction without regard to whether the defendant was only briefly in the state or whether the cause of action was related to his activities there. Although research has not revealed a case deciding the issue in every state's courts, that appears to be because the issue was so well settled that it went unlitigated. Most states, however, had statutes or common law rules that exempted from service of process individuals who were brought into the forum by force or fraud, or who were there as a party or witness in unrelated judicial proceedings. These exceptions obviously rested on the premise that service of process conferred jurisdiction. Particularly striking is the fact that, as far as we've been able to determine, not one American case from that period, for that matter, not one American case until 1978, held or even suggested that in-state personal service of an individual is insufficient to confer personal jurisdiction. Commentators were also seemingly unanimous on the rule. The American jurisdiction practice is, moreover, not merely old, it is continuing. It remains the practice of not only a substantial number of states, but as far as we are aware, all the states and the federal government, if one disregards as one for this purposes the few opinions since 1978 that have erroneously said on grounds similar to those that petitioner presses here, that this court's due process decision rendered the practice unconstitutional. We do not know of a single federal or state statute or single judicial decision resting upon state law that has abandoned the in-state service as a basis for jurisdiction. Many recent cases affirm it. Despite this formidable body of precedent, petitioner contends, in reliance on our decisions applying the international shoe standard, that the absence of continuous and systematic contacts with the forum, a non-resident defendant, a non-resident defendant can be subjected to judgment only as to matters that arise out of or relate to his contacts with the forum. This argument rests on a thorough misunderstanding of our cases. The view of most courts in the 19th century was that a court simply could not exercise in personam jurisdiction over a non-resident who had not been personally served with process in the forum. Benoit v. Neff, while renowned for its statement of the principle that the 14th Amendment prohibits such an exercise of jurisdiction, in fact sets forth only as dictum and decided case, which involves the judgment rendered more than 2 years before the 14th Amendment's ratification under well-established principles of public law. Those principles embodied in the due process clause require, we said, that when proceedings involve merely a determination of personal liability of the defendant, he must be brought within the court's jurisdiction by service process within the state or his voluntary appearance. We invoke that rule in a series of subsequent cases as either a matter of due process or a fundamental principle of jurisprudence. Later years, however, saw the weakening of the Benoit rule. In the late 19th and 20th century, changes in the technology of transportation and communication and the tremendous growth of interstate business activity led to an inevitable relaxation of the strict limits of state jurisdiction over non-resident individuals and corporations. Hansen v. Dinkla. States require, for example, that non-resident corporations appoint an in-state agent upon whom process could be served as a condition of transacting business within the borders, and provided in-state substituted service for non-resident motorists who caused injury in the state and left before personal service could be accomplished. We initially upheld these laws under due process clause on grounds that they comply with Benoit's rigid requirements of either consent. C. Hess v. Pawlowski, or presence. As many observe, however, the consent and presence were purely fictional. Our opinion in International Shoe cast those fictions aside and made explicit the underlying basis of these decisions. Due process does not necessarily require the states to adhere to the unbending territorial limits on jurisdiction set forth in Benoit. The validity of assertion of jurisdiction over a non-consenting defendant who is not present in the forum depends on whether the quality and nature of his activity in relation to the forum renders such jurisdiction consistent with traditional notions of fair play and substantial justice. Subsequent cases have derived from the International Shoe Standard the general rule that a state may dispense with informed personal service on non-resident defendants in suit arising out of their activities in the state. As International Shoe suggests, the defendant's litigation-related minimum contact may take the place of physical presence on the basis of jurisdiction. Nothing in International Shoe or the cases that have followed, however, offer support for very different proposition petitioner seeks to establish today, that a defendant's presence in the forum is only unnecessary to validate novel, non-traditional assertions of justice, but itself is no longer sufficient to establish jurisdiction. The short of the matter is that jurisdiction based on physical presence alone constitutes due process because it is one of the continuing traditions of our legal system that define due process standard of traditional notions of fair play and substantial justice. That standard was developing by analogy to physical presence, and it would be perverse to say it could now be turned against the touchstone jurisdiction. Petitioner's strongest argument, although we ultimately rejected, relies on our decision in Schaefer v. Hittner. In that case, a Delaware court hearing a shareholders' derivative suit against a corporation's directors secured jurisdiction quasi in rem by sequestering the out-of-state defendant's stock of the company. The situs of which was Delaware under Delaware law, reasoning that Delaware sequester restoration procedure was simply a mechanism to compel the absent defendants to appear in a suit, determine their personal rights and obligation, we concluded that the normal rules we had developed under international jurisdiction over suits against absent defendants should apply. Delaware could not hear the suit because the defendant's sole contact with the state ownership of property there was unrelated to the lawsuit. It goes too far to say, as petitioner contends, that Schaefer compels the conclusion that a state lacks personal jurisdiction over an individual unless the litigation arises out of the activities of the state. Schaefer, like international shoe, involve jurisdiction over an absent defendant, and it stands for nothing more than the proposition that when the minimum context that is a substitute for physical presence consists of property ownership, it must, like other minimum contexts, be related to the litigation. Petitioner wrenches out of its context our statement in Schaefer that all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe and its progeny. When read together with two sentences that preceded it, the meaning of the statement becomes clear. The fiction that an assertion of personal jurisdiction over property is anything but an assertion of jurisdiction over the owner of the property supports an ancient form without substantial modern justification. Its continued acceptance will serve only to allow state court jurisdiction that is fundamentally unfair to the defendant. We therefore conclude that all assertions of state court jurisdiction must be evaluated according to the standards set forth in international shoe and its progeny. Schaefer was saying, in other words, not that all basis for the assertion of impersonal jurisdiction, including presumably in-state service, must be treated alike and subject to minimum context analysis of international shoe, but rather that quasi and rem jurisdiction, that fictional ancient form and impersonal jurisdiction are really one and the same and must be treated alike, leading to the conclusion that quasi and rem jurisdiction, that form of impersonal jurisdiction based on property ownership, contact, and by definition, unaccompanied by personal in-state service, must satisfy the litigation relatedness requirement of international shoe. The logic of Schaefer holding which places all suits. The logic of Schaefer holding which places. The logic of Schaefer's holding which places all suits against absent non-residents on the same constitutional footing, regardless of whether separate Latin label is attached to one particular basis of contact, does not compel the conclusion that physically present defendants must be treated identically to absent ones. As we have demonstrated at length, our tradition has treated the two cases of defendants quite differently, and it is unreasonable to read Schaefer as casually obliterating that distinction. International shoe confined its minimum context requirement to situations in which the defendant be not present within the territory or the forum, and nothing in Schaefer expands that requirement beyond that. It is fair to say, however, that while our holding today does not contradict Schaefer, our basic approach to the due process question is different. We have conducted no independent inquiry into the desirability or fairness of the prevailing in-state rule, leaving that judgment to the legislators that are free to amend it. For our purposes, its validation is its pedigree, as the phrase traditional notions of fair play and substantial justice makes clear. Schaefer did not conduct such an independent inquiry, asserting that traditional notions of fair play and substantial justice can be readily offended by the perpetration of ancient forms that are no longer justified, as by the adoption of new procedures that are inconsistent with basic values of our constitutional heritage. Okay. Perhaps that assertion can be sustained when the perpetuation of ancient forms is engaged in by only a very small minority of states, where, however, as in the present case, a jurisdictional principle is both firmly approved by tradition and still favored. It is impossible to imagine what standard we would appeal for the judgment that is no longer justified, while in no way receding from or casting doubt upon the holding of Schaefer or any other case we affirm today, our time-honored approach. For new procedures, hitherto unknown, the due process clause requires analysis to determine whether traditional notions of fair play, and substantial justice have been offended. But a doctrine of personal jurisdiction that dates back to the adoption of the 14th Amendment and is still generally observed unquestionably meets the standard. But a doctrine of personal jurisdiction that dates back to the adoption of the 14th Amendment and is still generally observed unquestionably meets that standard. Okay, we are going to stop here and pick back up at section 3. Thank you for tuning in to this morning's episode of Legally Marette, Legally Raven Haired. Goodbye.